All right.
Some hair dye.
Ms. Conway, good morning. This is Judge Middleton. Your lawyer, Mr. Truckee, is with us. He is in the conference room, so he can speak privately with you. This is the time for your pre-exam conference in a charge of resisting and obstructing a police officer. It's alleged that on September 16th, that you did resist or obstruct Deputy Detective Jason Oughton from the Sheriff's Department. You're charged as a fourth habitual offender, which makes that punishable, I think, by up to 15 years imprisonment. Mr. Ross Truckee was appointed to represent you in this matter. Mr. Marvin offers attempted resisting and obstructing with no supplementation, meaning it's a 1-year misdemeanor and a 1 count of retail fraud second. Restitution on all.
I was at my house.
All right. Well, you got 3 retail frauds pending: 241842, 241843, and 241847. There's 3 of them in short order. They're set for last pretrial for August 17th. I let you out on a personal recognizance bond because I had to. You'd been in custody for 28 days. There was a plea offer to resolve all of those. You declined the plea offer, and I gave you a PR bond. In fact, I think you declined the plea offer so you could get a PR bond. Anyway, you got out. Now, shortly after you got out, you got rearrested on this resisting and obstructing charge. Bond is $1,000 cash or surety in that case. The matter is set for a pre-exam conference today. There is an offer to plead to a misdemeanor to resolve that case and 1 misdemeanor to resolve all of your other cases. Mr. Truckee, would you like to talk privately with her in a breakout room?
Yes.
Yes. All right, Ms. Conway, I'm going to open a breakout room. And when you see the button that says join, click on that. Can you see it? And Shorty went. I can't exactly tell what it is she allegedly did in the R&O. There's not any.
Well, Ross says you need to see the video. It lasts all of about 30 seconds.
There's no bond information. Well, here it is. Let's take a look.
So I guess I'm going down to Dave's office. We'll all stand around and watch the video.
No trespass.
Is her issue drugs or mental?
Yes. And yes. Yeah, she wouldn't leave when directed, which I guess could be resisting, obstructing, and then she pulled away. It ain't much of a resist and obstruct.
I mean, I was looking at the number of times that they had investigated previously from, I think it was from Walmart.
Well, she's
from Myers.
She is struggling. 43 seconds.
Is it Three Rivers Homecoming week?
I don't know. I went to the first game of the season and then I sort of lost track.
Just noticed you mentioned a couple times the graduation dates, and maybe you're just feeling wistful.
No, I remember when he was in school. My wife was teaching there then, and he went to school with my kids.
A little hard for us to remember that far back.
Yes, I'm sorry.
Well, I always heard Plato was a wonderful teacher.
It was Socrates.
It was Aristotle. Plato wasn't a teacher, but Aristotle was apparently one of Alexander the Great's teachers. All right, we return to Miss Conway, which is the felony file, resisting and obstructing. Had an opportunity to speak with your attorney, Mr. Truckee. Mr. Truckee, what's the situation here?
Mrs. Conway, it appears is not accepting the offer today and would like to be heard about the possibilities of a PR bond.
All right, I'm going to set this for a prelim for October 8th at 1 o'clock. Bond is set in the amount of $1,000 cash or surety. Generally, I don't rule on the bond until the time of the prelim, but Mr. Truckee, what do you want me to know about bond?
Ms. Conway reports to me several medical concerns that she has for herself, that she feels are going untreated while in custody. For that reason, she requests a bond on her own recognizance so she can seek treatment.
Response, Your Honor.
Yes?
Your Honor, I think the court has let her out on her own recognizance previously, and she's failed to comply with terms and conditions and gotten other violations. And
I'm not sure she can hear you. You're leaned back and
Oh,
you're not
okay.
speaking very loud.
And secondarily, Your Honor, I think that with the substantial substance abuse issues, maybe she's better off continuing to remain in custody.
All right, Ms. Conway, you've got multiple cases pending, and I'm watching you disintegrate before my eyes. I first met you a couple of years ago when you came down here to St. Joseph County, and you are withering away. You have 3 retail fraud cases pending. Just a minute. You have 3 retail fraud second degrees, which there was an offer to resolve everything, but you declined so you could get a PR bond. I let you out on a PR bond on September 6th. I said, where are you going to go? And
I got plenty of money to stay at motel rooms.
say that again.
I have plenty of money to stay at motel rooms. Where do you think I was at?
I didn't understand anything you said. It may be more a
I have
reflection of
plenty
me.
of money to stay at motel rooms. Where do you think I was at before I went to my grandma Bingham's house?
Yeah, you're homeless and you're not welcome at Miller's Mill Road, and they told you.
Yes,
that.
I am, actually. All I got asked to is to leave for a minute and come back.
Anyway, this is a felony charge with multiple supplementation. You're homeless, you're struggling with, well, you aren't now. I have a home for you, the jail, but the bond is only $1,000 cash or surety. Magistrate came to see me and said, what do I do with this? I'll reserve on your motion for a bond until the time of the prelim.
This is illegal. I can't stand long enough to use your telephone. Medically.
Um,
So you're telling me you're gonna force me to take a plea deal just to get out of jail?
no, I'm not. I'm telling you, you can have a trial on this if you'd like.
I want you, so you're telling me if I plead guilty, you're gonna let me out of jail? Okay, let's plead guilty and I'll take your, what do you call it? 30 day, I'll say, hey, guess what? I'm gonna take you back to court. So guess what? I'm gonna plead guilty today and I'm gonna take you back to court in 30 days. How about that?
How about we talk about this next Tuesday at 1 o'clock? I'm not sure that she's competent. See how she's doing after a while. I didn't understand most of what she said.
Like Paul says, he doesn't speak Methanese.
But not in a mind right now to enter a plea. So motion for bond reduction is continued until time of prelim. We'll see how she's doing next week, but she is homeless, which is how she got in this situation. She was where she wasn't supposed to be. They kept trying to get her to leave. She wouldn't leave. It wasn't much of a struggle.
Well, isn't one of her trespasses at her grandma's?
Oh, there's a bunch of trespasses and then
At her
the
grandma's
retail
place.
frauds, and she owes money, and yes, she's not doing well. It goes without saying. All right, Ross, we're down to 2 cases.
I'm gonna go talk to Dave quick on both of them.
All right, I'm gonna stop the record and the live feed. We've been on here 3 hours straight.
In the case of People v. Conway, Judge Middleton conducted a pre-exam conference for defendant Miss Conway, who is charged with resisting and obstructing a police officer as a 4th habitual offender, carrying a potential 15-year prison sentence. The prosecutor offered a plea to attempted R and O, a 1-year misdemeanor, plus 1 retail fraud misdemeanor to resolve all her pending cases, which include 3 separate retail fraud second-degree charges. The judge reminded her that she had previously declined a global plea offer and was released on a personal recognizance bond, but shortly afterwards she was arrested again on the present felony. Her attorney, Mr. Truckee, attempted to review the video evidence, which lasted only seconds, and requested a PR bond, citing her significant untreated medical issues. The prosecutor opposed the request, pointing to her repeated bond violations and severe substance abuse problems. Judge Middleton agreed, stating that Ms. Conway was disintegrating before my eyes, noting her homelessness, trespassing history, retail thefts, and clear mental and physical decline. Ms. Conway became agitated, insisting the court was forcing her to plead guilty to get out of jail, then attempted to initiate a plea on the spot, prompting the judge to question her competency. Concluding that she was not in a stable mental condition to enter any plea, he refused to change the bond, kept the $1,000 cash or surety bond in place, and adjourned the matter to next week to reevaluate her condition and address the bond motion at the time of the preliminary hearing. For more information, like and subscribe my channel.